Good afternoon and welcome. My name is Rochelle Chaplinsky, and I am a Senior Trust Officer with BECU Trust Services. We are excited to have you join us for today's webinar, Transitioning to Adulthood for Families with a Child with Disabilities, presented by Josh Brothers. This is a topic that is near and dear to my heart, both as a professional in assisting the families and clients that I work with, and personally as a parent. Before getting started, I'd like to go over a couple housekeeping tips. Today's webinar will be recorded. At the end of the presentation, we have set aside some time to answer questions. For those of you who do have questions, please enter them in the question box on your toolbar, and we'll get to those at the end of the presentation. You'll also receive a survey after the presentation via email. We welcome your feedback, and it's important to us in planning future webinars. I'm happy to have Josh Brothers join us today. Josh is an experienced advocate and attorney in disability and elder law, estate planning, and probate. He is a longtime leader at Brothers Henderson, PS. A partner at the firm for over a decade, his practice focuses on litigation and settlement planning, the development, implementation, and administration of special needs trusts and other types of trusts, estate planning, guardianships, benefits advocacy, benefits litigation, and probate. With a strong commitment to the disability and senior communities, Josh actively serves as a leader and advocate for numerous community organizations. Please join me in welcoming Josh.
Thank you, Rochelle, and hopefully everyone can hear me just fine and see the PowerPoint here. Well, yeah, I'm absolutely happy to be doing a presentation on this topic. This is one that also, like Rochelle, is very near and dear to me. My entire career has started and been largely focused on assisting those with intellectual and developmental disabilities as well as acquired disabilities. There's a lot of practitioners in our area that I think start with more of an elder law or age-related disability bent and find themselves into intellectual and developmental disabilities because there's some crossover. I went the opposite way, and I absolutely love working with this population and helping families. The point of adulthood, where the child is becoming an adult, can oftentimes be the first contact that I have with a family, and often the start of a very long relationship. So first piece of advice here for families is really to start thinking about making a relationship with an attorney at that point. When your child becomes an adult, if you have not already found an attorney that works in the area of disability law, this is a great time to do it. And this is not something that you need to do in a single meeting and that's it, and you never see the attorney again. As I mentioned, I've got relationships with with clients that have lasted for many years, and that's often the case with these. I had actually my college roommate actually call me, and I met with him and his wife today because they have a child with a developmental disability, and she's only in 8th grade right now. And so they've got some questions about benefits and that sort of thing, but I know that that's going to be a lifelong relationship where you don't call on me every day, but you do call on the attorney, and you want to have somebody to turn to when these issues do come up. Okay, so let's sort of hop into this. This transition to the adulthood is a bit for families, I think, like falling off a cliff while you're blindfolded, because you don't really know a whole lot about what's ahead. And the life and way things have operated thus far, a lot of that really shifts when the child becomes an adult. Some of the assumptions that you've made about your ability to make decisions for that individual or to care for them are no longer true. And oftentimes benefits that were not available to the child as a minor become available to that individual. So it's a huge transition. Having somebody walk you through it so that you're not just jumping off a cliff can be very, very helpful. So what are those things that you should be thinking about as you move to adulthood for a child with disabilities? So I'm just going to sort of go through these topics. These are the things that I really kind of think of as your checklist of things to be thinking about as your child starts reaching that age of 18. So first, decision making. How are we going to make decisions for this individual? What's that going to look like? That assumption, one of those assumptions that we often make is that you can continue to make decisions for the individual. And that assumption and that default actually turns on its head when the individual turns 18 years old, and they are presumed to have capacity unless some step is taken to help them with decisions. There's a variety of different ways, we'll get into that, but decision making is the first thing you should be thinking about. Next, public benefits. There are a huge variety of public benefits that can come up. The main ones that come up at the age of 18 are really Social Security benefits, and specifically SSI and Medicaid. And the reason that those often come up is those are the benefits that generally were not available to those who are under the age of 18. And again, we'll talk about eligibility and how to think about those. The other really large benefit to be thinking about at the age of 18 are DDA benefits, so Developmental Disability Administration benefits. A lot of folks actually are already on those programs or may be eligible for DDA when they reach that age of majority. But if you're not, this is a great time to start into that. And we'll spend some time talking about DDA benefits. Next, you want to be thinking about education. And that can mean a variety of different things. That can mean education in a transition program. That can mean college education with accommodations. That could mean a college program that's specifically aimed with those with disabilities. So thinking about education and what that looks like is another important step and thing that you want to be thinking about. Next, employment. That might not be an immediate issue at the age of 18, or it might be. But you're going to want to think about how that employment is going to look and how it's going to work for the individual. Housing, again, maybe not an issue exactly at the age of 18. It may be something that's a little bit more long-term, but thinking about the housing for that child. Is this someone who is going to remain in the home in the short term? Are they going to be out on their own? And if they are out on their own, what does that environment look like? So thinking about housing and thinking about what's out there and available is an important step. By the way, I'll only touch probably a little bit briefly on employment and employment education and housing. We'll talk very briefly about those. Any one of these topics could be a presentation in and of itself. So we're really just sort of touching at a very surface level on these things, but it will help give you some understanding of the things you should be looking for. Next, estate planning. If you have not created your own estate planning, this is a great time to do that. It's a great time to say, boy, you know, we don't have documents in place, or if I do have documents in place, it's a good time to review those and make sure they are still current. Very often what we find is that maybe there are estate planning documents that have been in place since the child was very young, maybe even before diagnosed with any sort of disability, or even before the child is born. And the situation has changed dramatically from either a circumstantial perspective for the child or a financial perspective for the parents. So estate planning is a great way to start thinking about that and to think about how it is you're going to plan for your child after you are no longer there. And then finally, again, we'll touch very briefly on planning for the child's own funds. So what are you going to do if they're out earning money? How are you going to deal with that? What if they get an inheritance? What's going to happen with that? So starting to think about that. Again, likely not an immediate issue, with one little caveat on there, which is thinking about things like 529 plans, or if there are Uniform Transfer to Minor Act UTMA accounts for that individual. You'll want to start thinking at this point, and you may be required to start thinking at this point about what happens with those funds and where they should go. Okay, so that's sort of the roadmap of what we're going to talk about today. We will go ahead and just hop right in and start talking about the first topic, which is decision making. So there are a variety of different options for decision making. Very often this gets couched as the guardianship discussion, and guardianship, or what is now called conservatorship, is really only one of the options to be thinking about. A thorough discussion about this with an attorney will walk you through what guardianship and conservatorship means. There's a difference between those two, guardianship being really kind of personal decisions about the individual, decisions about medical care, is the person going to drive, what's the IEP look like, with the school district and its individual education plan. For those of you who are not familiar with acronyms, this is definitely a world of acronyms. I assume most of you know what IEP means, but just in case. Conservatorship, by contrast, is really about the financial side of things. So what happens with money? Is the person going to sign a lease or a contract to purchase a vehicle, for example? Are they going to sign a rental agreement? Anything that has to do with money really falls on the side of conservatorship. And it is not a one-size-fits-all solution. Again, very often that guardianship discussion, it's like, here's guardianship and you need guardianship. That can mean a lot of different things for a lot of different people. And like any option or any of the things we're going to discuss, it should be personalized to that individual. We need to be thinking about what this person's talents are, where they have abilities, and where they have some challenges. And those places where they have challenges, guardianship and conservatorship can step in. But guardianship and conservatorship is not the only option that you should be considering. There are also powers of attorney, which is something short of guardianship. This is a voluntary agreement between that individual. If they have capacity to sign a power of attorney, it allows them to voluntarily give away or allow another person to make decisions with them. Powers of attorney do not cause the person to lose their ability to make decisions for themselves. As a matter of fact, they can override the person acting under the power of attorney. They can terminate the power of attorney at any time that they have capacity, and they can change who serves under the power of attorney. So they have a lot of leeway under that power of attorney, and it can be a wonderful solution in the right circumstances. However, they're not a great option for protecting somebody who you think might make a bad decision for themselves. Guardianship and conservatorship, just as a little contrast here, that is actually a court proceeding in which the individual's ability to make some or all of their decisions is actually taken away by the court and provided to a guardian or conservator. Oftentimes that's the parents, oftentimes it's simply a continuation of what you've been doing your whole life as parents for the individual, but it is an actual court process to remove rights. Because there is a court process and because there is a removal of rights, if that person goes to make a decision where the right to make that decision has been removed, and let's just say it is a credit card agreement, and they've gone and signed a credit card agreement and racked up debt on a credit card, you can come in with your guardianship and conservatorship paperwork after the fact and say, this person didn't have capacity to make the decision. Here's the paperwork that shows that, and the credit card company does not have a valid contract and they will write off the debt. A power of attorney, though, does not do that because there has been no finding that the individual lacks the ability to make decisions for themselves. It is just simply an agreement for them to allow somebody else, again, oftentimes this is the parents, to make decisions for them. So powers of attorney can be a wonderful alternative to guardianship and conservatorship, but it's got to be used in the right circumstances. In addition, one alternative is representative payee. What a representative payee does is a very narrow role of managing the individual's Social Security benefits. So it is really focused on how those Social Security benefits are managed. Frequently, if the person has a significant enough disability, this may be the only source of income and maybe the only thing that is a major concern. So representative payees can be used as an alternative to any of these other options. I also mentioned too that very frequently these options, all of the ones I'm listing, they can be used in conjunction with one another. So for example, maybe the person has some difficulty making decisions with money and we decide they need a conservatorship. So we're going to do a conservatorship to manage their money and to remove their ability to contract and to maybe get themselves in financial trouble or financially exploited. But we think they have the ability to make their own medical decisions, and maybe we do a power of attorney for medical decisions so mom and dad can be in the room, can help with the decisions, but not as intrusive as a guardianship might be. So you can use these things in conjunction with one another. Don't think that they are mutually exclusive. Another option for decision making is our trusts. Trusts are really focused only on whatever funds are placed into that. So again, a pretty narrow use for this. It has nothing to do with any of your personal decisions about where you're going to live, are you going to get a driver's license, your medical care. This really only has to do with the funds that are placed into the trust. That trust is a whole separate legal entity from the individual. There will be a trustee that is in charge of managing that. So it allows for management of the funds and a very specific set of funds. I would also mention too that the trust doesn't cover anything that's not that's outside the trust and not placed within the trust. So great example, maybe we have a piece of real estate, let's say it's a condominium. We want that individual to have that available to them, but we don't want them to have the ability to sell that or to encumber that property, do something they shouldn't with it. Maybe we place that condominium in a trust and the individual's getting, I don't know, let's say they're working at Safeway and they're getting wages from that. The trust has nothing to do with the funds that are coming in from Safeway. It only has to do with that property you've placed within trust. So again, trust can be a really good alternative to guardianship under the right circumstances. In addition, I think one that's often underlooked is case management. There are folks out there called case managers who can really step in and help a lot with navigating a lot of the systems I'm going to talk about, and can also help with decision making. So case managers, or care managers as they're sometimes referred to, can be a great alternative for guardianship or conservatorship. In addition, supported decision making. So this is the idea of supporting the person in the decisions. You may have formal agreements about the process they're going to go through making decisions, who they're going to talk to. So it really empowers the individual to make the decision themselves, but sets up a framework for them to make the decision and to have people there to help support them in that decision making. So all these options are really available to you and to an individual. Again, very personalized decisions. So you want to be paying close attention to what's right for your child and what's right for the individual who's reaching 18, because not every solution will be right for every situation. Okay, so let's talk a little bit about guardianship and conservatorship, because this is the sort of primary thing that people go to, I believe. So the first thing to be aware of is that the law as of January 1st of this year was completely overhauled in Washington State. These are Washington State laws. We passed something called the Uniform Guardianship Act a few years back. The legislature has allowed several years to implement it because it is such a significant change to the guardianship law in this state. However, we do now have this Uniform Guardianship Act that is the law of the land. Fortunately, for those of you who are not in guardianship or conservatorship yet, you won't know the difference of what the law was like before. For those of you that are already in it and are converting to guardianship and conservatorship, just be aware there's going to be some pretty significant changes between those two laws. So for purposes of thinking about creating a guardianship and conservatorship, there's some things to be thinking about. First of all, is that the law tells us to look for the least restrictive alternative. That means if a power of attorney or a trust or supported decision making is an appropriate alternative to guardianship, we should go with that first. We don't want to automatically go to guardianship and conservatorship. I will tell you too that oftentimes, and I've certainly had this scenario, we may start with something like a power of attorney and we might see how it works. And if it is not working, if the person's making bad decisions, then we move towards a guardianship. So that's a fairly common scenario. And I will say it tends to be most common with folks who have intellectual disabilities or are on the autism spectrum, because oftentimes we don't know until they get in the situations how they'll do. We have clients that have done wonderful and really like been able to make those decisions, and we have clients that have gone the completely other direction. But we should start with the least restrictive alternative to guardianship or conservatorship. In addition, there is full versus limited. Full simply means that all of the rights that can be taken from the individual and granted to the guardian or conservator who's going to be making decisions for them. All the rights that are allowed under the law are granted to that guardian or conservator. Limited is anything short of that. And a limited guardianship or conservatorship can really be customized to the individual's circumstances. We can get very creative in how we word these guardianships and conservatorships. We can be very narrow, we can be very broad. I will say that if we're considering guardianship and conservatorship, often the biggest issues that come up are the right to marry and divorce, the right to drive, the right to vote. Those tend to be the big ones. Sometimes it's more than that. They want the ability to manage some of their finances. They want the ability to maybe be involved in their medical care. We can be very creative in this. The one I always think of that is probably one of the most narrow guardianships I've ever done is that we had an individual who clearly needed help with finances. He needed help with the financial support. So we went with what was at that time called full guardianship of the estate, which is a full conservatorship now. On the personal side, he really didn't need a whole lot of help, but he was having one problem. And the problem was this, is that the recruiters for the armed services kept calling him and they would get him on the phone and he couldn't say no to these folks. So what we ended up doing is doing a very narrow guardianship that focused only on his ability to contract with enlist into the armed services and said he had no ability to do that. The court agreed, the court entered our order, and we were able to use that to prevent those folks from calling him and to prevent him from joining the armed services because he simply couldn't say no to them. The interesting thing about that case too is something I think is very important to note as well is people often think guardianship and conservatorship, once it's in place, that's it, it's done. And I would say that the law actually says the exact opposite. The guardianship and conservatorship should adjust as the person's scenario adjusts. So if we have an individual who regains capacity and the ability to make some of their decisions, if they show their ability to do that, we should restore their rights. With that case, we actually ended up getting rid of the guardianship and conservatorship at the end of the day because he showed a capability to manage his own funds. As I mentioned, you sometimes are experimenting and seeing how people will do. In that scenario, he really showed he was capable of doing it, wasn't really vulnerable to exploitation. So we ended up removing it and putting in a power of attorney in place instead of the conservatorship, and the guardianship went away. Okay, so the other thing to be aware of here, we've talked a little bit about guardianship versus conservatorship. Again, the way to sort of think of this, conservatorship is money, guardianship is everything else. So know that you can have one or the other, and each of them can be full or limited. So you have some combinations of things you can do with the guardianship and conservatorship. In addition, you've got to make sure that you've got a good understanding of the legal process and what it looks like to get from the point where you have an individual that's not under a guardianship and conservatorship to the point where they actually do have a guardian or conservatorship in place. That involves a court proceeding, as I mentioned, where there is a finding at the end of the day. If you're successful at getting the guardianship or conservatorship, the individual lacks capacity to make some or all of their decisions for themselves. Now, that's not something that the court takes very lightly. There are a lot of protections in place. There is a lot of legal procedural safeguards in place to make sure that we get from that point, when we get from point A to point B, that we don't do that unnecessarily for an individual. So you see a lot of procedural safeguards, you see a lot of things in place to help make sure that the person actually is someone who needs a guardianship or conservatorship. So, you know, I think the one we hear about the most these days tends to be Britney Spears and what happened to her and the restoration of her rights that occurred earlier this year. And yes, absolutely, there are abuses in the system and that can happen, or things that can occur. Honestly, we don't really know what happened in that case because the records are sealed, as they probably should be. Those are very personal things towards her and what was happening in her life. And so we probably don't know everything. But if there is a concern that this is going to be an overstepping, know that we do have a lot of safeguards in place. Specifically, things to be aware of is that the court is going to appoint somebody called a court visitor, and their job is going to be to watch out for your son or daughter's best interests or the individual's best interests. Doesn't necessarily mean they're advocating for what that person is saying. It means they're advocating for what they believe to be in their best interests. As part of that, they're going to be looking at medical records, they're going to be interviewing folks, and they ultimately provide a report to the court with recommendations. In addition, the court, unless there is a specific finding otherwise, will appoint an attorney to represent the individual. So they will have that right under the process to be represented by counsel, who will advocate for their expressed wishes. Now, clearly with developmental disabilities, this can be a very broad range in whether or not they need or want that. For folks with severe cerebral palsy who are unable to speak or communicate, we might not need an attorney to represent them and to be telling the court what their expressed wishes are, because we're really not able to decipher that necessarily if they're really truly disabled to the point where they cannot communicate. However, for somebody who is higher functioning, it might be an important thing to have them exercise and have the attorney representing their interests. But do be aware that that may be a part of the process. In addition to that right, the individual who is the subject of the guardianship or conservatorship proceeding is going to have other procedural rights. I think hopefully the most obvious one is they have the right to object to the request. They have the right to tell the court, I don't want a guardianship or conservator. I want to be able to represent, or I want to be able to make my own decisions, and I don't want to lose that right. They have the absolute right to present that to the court. They also have the right to cross-examine witnesses. They have the right to put on their own witnesses and evidence of their capacity to make decisions. So they have these rights in the process. The other right to be aware of that they have is that they do actually have the right to a jury trial. I will say that it is a rare circumstance where you end up in a jury trial. It's a pretty rare circumstance you even end up in a contested proceeding where the person is saying, I don't want the guardianship or conservatorship. But it does happen. It tends to happen, I would say, more later in life for individuals who guardianship or conservatorship is being sought for than it does for the 18-year-old, but it does occasionally happen at that age. So be aware that there are procedural safeguards and rights in place for that individual. In addition, you need to be aware of what the duties and limitations are for the guardian or conservator. Even if you have full guardianship and conservatorship, does not mean that you have full authority over the person's life. As far as duties go, you're going to be required to make decisions which the individual would make if you're able to decipher that, and if not, decisions that you believe are in the person's best interest. You are also required to report back to the court on a regular basis. In King County, so the Seattle area, and most of the surrounding counties, that tends to be that you present a report at the 1-year timeline, so 1 year after appointment, and then the court, if there are not significant assets in the estate or in the person's name, the court is allowed and oftentimes will move to a 3-year reporting period. So be aware that you've got these duty and obligations. You're going to be required to provide accountings, so account for how you spent the individual's money, provide information about how they're doing, reporting to the court about when there's a change in circumstance, such as a change in their ability or a change in where they're living. So these duties are going to exist for a guardian or conservator, and is probably one of the more burdensome things that I think is placed onto families and to parents once the kid is 18. Of course, it seems sort of frustrating that the things you've been doing all your life, now you have to report to a court and explain what you're doing. But again, know that those are in place because not everyone has done a good job of that. And not everyone is watching out for their own child or for the individual's best interests. As far as limitations go, just a few to be aware of. You can't force the person to live anywhere against their will. The only way you can do that is through an Involuntary Treatment Act proceeding, which really has to do primarily with mental health and temporary holds and placements in places like hospitalizations for a short-term period, or in more permanent placements in places like Western State Hospital. But you can't force the person to live anywhere against their will. Likewise, sterilization procedures, those procedures you really have to go through a pretty extensive court proceeding in order to get to the point where you're allowed to do that. You cannot just do it on your own. Similarly, medications, you cannot force a person to take medications against their own will. You also cannot isolate them and limit their social contacts. There's a process for doing that in order to protect the individual called a Vulnerable Adult Protective Order, or a VAPO. So there are ways to deal with restricting social interactions that are inappropriate. But as a generalization, that's not something that you can do as the guardian if the person is insisting on it. And then finally, electroconvulsive shock therapy is another exception on a limitation for the guardian or conservator. Again, there's a court process for doing that. Not saying that it doesn't happen. We've had it happen in our office where that's come up, but it is not something that happens very regularly. But again, just something to sort of keep on the radar as some limitations. Okay, so we're going to shift the discussion now to our next topic, which are public benefits. As I mentioned, we're really not going to talk about housing and food assistance in much detail, but just be aware that they're out there. And the eligibility for those benefits really is largely dependent on income rather than assets owned by the individual. And that hopefully will make sense as we start talking through some of these benefits. So the first one, Social Security. This is a cash benefit, just be aware that's out there. One benefit we'll talk about. We'll also talk about Medicaid and Medicare, which are the primary systems for medical assistance. Medicaid also has another component to it that we'll discuss. As I mentioned earlier in the presentation, Developmental Disabilities Administration benefits, DDA benefits. There's also housing benefits that are out there, food assistance benefits. So those are kind of the primary benefits that I would expect to be looking at. Not all of them are going to be available, certainly not available right away in every scenario, but these are the benefits to be thinking about as your child turns 18 and we're thinking about how and what we're going to be applying for and getting for this individual. Okay, so Social Security benefits. So the first one I want to talk about is something called SSI, Supplemental Security Income. Again, world of acronyms, SSI is that one. This is a cash benefit and it's currently at $841 a month. That's as of the first of this year of 2022. That is one that is subject to cost of living adjustments or COLAs. So I would expect that to go up again this year. It does generally tend to go up every year. It doesn't happen every year, but most years that's going to go up. And certainly this year it's going to go up. That money is intended to cover the person's basic food and shelter expenses, which may have you scratching your head about where in the greater Seattle area is $841 going to cover all your food and shelter expenses, but that's the number that they have determined. In addition, some states, not Washington currently, but some states do provide a cash supplement to that SSI. And for many states, including Washington, SSI will actually serve as a gatekeeper into Medicaid and other benefit programs. So in Washington, if you receive any amount of SSI, you can get less than the maximum benefit of $841, by the way. Any amount of SSI will make you categorically eligible for Medicaid, and that pushes you into automatic eligibility for other benefits. So important oftentimes not because of the dollar figure that it provides, but important because what it gets you access to. The other part of this is just what I would just term as general Social Security Administration benefits. And this is the benefit we have from paying into the system. So we see it on our paychecks, the money comes out, we're paying into the system. We know that if we ourselves become disabled, or when we retire most likely, we're going to be entitled to receive a Social Security benefit. That is true as well for individuals with disabilities. Obviously, if they work and they pay into the system, they can get the benefit back out. However, it's also important to note that if they are the child of a Social Security recipient or someone who has passed away and would have received Social Security, they can actually attach onto that parent's work history and receive a benefit. Again, probably not something that's immediately applicable for the age of 18, but something to be thinking about and planning for the long run. We then move to sort of our medical coverage, which are Medicaid and Medicare. Medicaid has two components to it. The first component is the medical assistance program. This is a no-cost medical program for individuals who meet the qualifications. There are no premiums, copays, and deductibles associated with this, so no out-of-pocket expense. The other part of Medicaid is long-term care. What long-term care covers is the ability to help the individual with activities of daily living. So those are a number of hours, and they say, look, you need care provider assistance either in the home or in an out-of-home placement. We're going to assess you and determine how many hours that's going to be. And so long-term care becomes a pivotal and large benefit for individuals with developmental disabilities that really do need that assistance with those activities of daily living and need care provider support. On the other side of this, we've got Medicare, and Medicare is really more like a traditional Medicaid or traditional medical insurance, meaning that it's going to cover hospital visits, doctor visits, prescription drugs. However, there are going to be premiums, copays, and deductibles associated with it. Also important to note that there is no long-term care with Medicare. So you may need, or the individual may need, to receive both Medicare and Medicaid. Medicare, much like the Social Security benefits I just mentioned, are tied to your work history and paying into the system. Again, not in the short run, but in the long run for the individual, they may qualify because of their own work history or because they are attaching to a parent's work history. So Medicare becomes a larger long-term benefit, while Medicaid tends to cover short-term, and the long-term care piece is also a critical component. Okay, so how do you get into these programs? Well, I've sort of split it up based on eligibility and how you get in. So for SSI and for traditional Medicaid, there are two components. There's a means test, and then there is a disability, blind, or over the age of 65 test. So that disability, blind, or over the age of 65, clearly the way we're fitting in is through a disability definition. What disability means is a lot of different things depending on the context. In this context, disability means the individual doesn't have the ability to engage in what we call substantial gainful activity, or SGA. What that means is that their disability prevents them from going out and earning an index number, which is currently $1,350 a month. Okay, so that's the definition of disability for SSI and Medicaid. That's the definition they're looking at. The second component for SSI and a traditional Medicaid program is looking at the income and the resources or the assets of the individual. Income really depends on the source of where the money is coming from. So there's earned and unearned income. And then there's a third type of income called in-kind support and maintenance. What in-kind support and maintenance, or ISM, is that this is, if you go back to thinking about what SSI covers, it's food and shelter. It means that nobody's providing them with cash, but they are providing them with food and or shelter for free or at a discounted price. So the way most families, this would come up for most families, is that their son or daughter continues to live with them after the age of 18. They apply for SSI, they qualify for SSI, and then SSI says, hey, look, you've got in-kind support and maintenance. And as a result, we're going to reduce your SSI benefit by up to 1/3. It's a presumption of 1/3. So income can serve to reduce the benefit. And in some cases, if it is direct income through earned income or unearned income, which those terms are kind of like what they sound like they are. Earned means the person goes out and work. For every $2 they earn, their SSI goes down by $1. Unearned income is anything but work. So someone gives them money, it's a dollar for dollar reduction after some small exclusions. So unearned and unearned income can serve to eliminate, reduce, and eventually eliminate. in-kind support maintenance, it really can only reduce the person's SSI payment. But income is a critical component when you're applying for SSI and Medicaid. In addition, assets become an important piece of this, meaning that the person, generally speaking, can only have $2,000 in their name. There are a number of exemptions here. I've listed them: primary residence with equity of under $955,000, vehicle that's used as the person's primary form of transportation, personal property, household effects, something called an ABLE account, and then special needs trusts. All of those sort of fit in as sort of exemptions or exclusions to the $2,000 limit. So you're going to be thinking about what money does this person have coming in, if any, and what assets do they have in their name. And those are the considerations for how we get the person qualified. If there's an issue here, particularly around assets, we can often deal with it. There are ways that we can move funds into one of the exemptions and still get the person to qualify. Important to note too that there is now Medicaid expansion, or what's often called MAGI Medicaid. That means MAGI is yet another acronym. It means Modified Adjusted Gross Income. And this type of Medicaid came around with the Affordable Care Act, Obamacare, whatever you want to call it. And it no longer had a category, so you don't have to be disabled anymore to qualify for this. As a matter of fact, they're not even going to look at your resources. Instead, they are just looking at your income and a specific type of income, and that is the modified adjusted gross income. In other words, earnings that show up on your tax return. So an inheritance is not necessarily, or a gift is not going to show up on your tax return, but if you go out and work, it's going to show up. You need to be 138% below the federal poverty level in order to qualify for that. Note, by the way, that in Washington State, Medicaid expansion does not apply to long-term care. It only applies to medical care and medical assistance. That means that if we are looking at long-term care, in other words, care provider support, we really have to default back to the traditional Medicaid qualifications. On the right-hand side of the board is just sort of Social Security and Medicare. I'm not going to talk about that in too much detail because, again, it's a bit more of a long-term issue. Just note that the definition is the same: disabled, blind, or over the age of 65, and it ties to a work history. Very frequently, that is the parent's work history as opposed to the individual. The one thing I would note there is that in order for that person to qualify under that program that allows them to attach to the parent's income and work history, they actually need to be disabled prior to the age of 22. So you're going to need some evidence and some information to show that they are disabled prior to the age of 22. And you likely don't want them to have a very significant work history, or if any, before they reach that age. Okay, so I think that's enough on SSI, Medicaid, and Social Security and Medicare benefits. Let's talk very briefly about DDA benefits. These are the Developmental Disability Administration. So I've listed citations here for you. For those of you who are familiar with legal citations, RCWs, those are the statutes that are passed by our legislature in Washington State. WACs, or Washington Administrative Code, those are the regulations that are not passed by the legislature, but are passed by the Department of Social and Health Services or various agencies in implementing these statutes. So I've given you the citations here if you want to look at them, if you're interested in some of the legal authority. So you've got those. DDA also, sort of, if you were looking at the umbrella of where it fits under, it's under DSHS, and I've given you the website for DDA right here. We'll give you a great link to applying for DDA and getting into those programs. Important to note for DDA too is that just because you are eligible does not mean you are going to receive services through DDA. That doesn't mean that it's not important to apply and become eligible. I truly think it is. First of all, it is a prioritized list on several of the programs, and they are waiting lists. And so people are often waiting, but they're in a prioritized way. If you want to get your name on the list and you want to qualify, you need to get yourself eligible or the child eligible so that they can get their name in line. The other reason that information is incredibly useful is that DDA eligibility, or the DDA program, in order to come back to the legislature and say we need more money, they need evidence and information that shows exactly who those folks are that need the services. So DDA becomes a large piece. I'm going to skip over these next couple of slides, but I would encourage you to look at it. They are the policy, the declaration of the policy, and the legislative intent. Those are really helpful in seeing what we're talking about, which is really a community-based program to help keep people independent in their homes. As you'll see from this slide, there are a very large number of services that are provided for individuals who qualify for DDA. And your only contact, if you get within DDA, you're not going to have a separate caseworker that deals with your long-term care. You're not going to have a separate caseworker that deals with your medical assistance. Your sole point of contact will be your DDA caseworker. And I find these folks to be pretty easy to work with, at least relatively speaking, for benefit agencies. They tend to want to get people services. They tend to want to get people qualified. They're not looking to exclude people. They want people in the system. They want to help people. They seem to be really kind of focused on that help for individuals, and not necessarily on, gee, why is this person trying to get in the system? So keep an eye on these services. It's pretty extensive here. The first step with Developmental Disabilities Administration is defining developmental disabilities. That's a pretty extensive process, and you're going to be required to provide a lot of information. But the basic definition of a developmental disability is one that is acquired and originated prior to the age of 18. I've included those 5 categories up here. Don't let those labels fool you, though. Sometimes they are actually much more extensive than what it might lead you to believe. But there is that disability that originated prior to the age of 18. It has to be expected to last indefinitely. So it's not like a broken leg where it's going to heal and you're going to return to relatively normal functioning. It has to be indefinite, and it does also have to result in substantial limitations. Okay, so I'm going to skip through a few slides here. I know we're running a little bit short on time. I want to make sure I've got time to answer a few questions if people have those. But do pay attention to these. I think Rochelle should be, if she hasn't already, sending these out as the PowerPoint slides. I intentionally included way more information here than I knew we'd be able to get to, because I wanted you to have these to come back and look at. So things to be aware of is that there's a DDD and DDA assessment. You're going to want to understand that and understand how that determines the outcome. That person-centered support plan that is the ultimate result of the assessment, a really critical piece. In addition, be aware that institutions, while they are the default, are not the preferred option. Instead, we are looking to these home and community-based service waivers, the HCBS waivers. And these tend to be the biggest benefit that you're going to find from DDA. This is what people want to get into because they provide the most extensive services. The idea behind the waiver is that you are actually waiving your right to a placement in an institution for placement in a home and community-based setting. So keeping people at home, keeping people in their communities, not moving them to institutions where they're isolated from the rest of society. So the waivers, there are waiting lists. They call it a database. So you want to make sure that you get on the database if you apply for DDA and you get within that system, because that's the waiting list that will get you there. So there is a backlog right now, and it's either waiting for people to come off when they pass away or come off for any other reason, or for the legislature to approve more funding. So this is really the primary benefit that I look at when I'm looking at DDA eligibility and sort of long-term of what you're going to need, because it can provide a whole ton of funding to help keep the individual in the community. So again, you can look over these slides. In addition, long-term care eligibility, this is really covered within the DDA assessment. but it's a little bit more extensive. The thing to note here is that the hours that an individual can get are anywhere from 0 to 393 hours of in-home care. It will also provide the level of funding that an out-of-home placement, such as an adult family home, will receive if the person's placed with them, so it tells you what's available for that individual. In addition, note that this is not structured for the developmentally disabled. It was structured for the elderly and has been adopted for individuals who are developmentally disabled, despite the fact that it's not really there. The DDA assessment is much more extensive than this. Unfortunately, it doesn't do a whole lot as far as providing services right now, but it's giving a lot of data. And hopefully at some point, we're going to move to a model where that DDA assessment information can be used to provide hours that are really specifically tailored towards developmental disabilities. Oftentimes that's supervision, direction, and those sorts of things that you may not have with folks who are elderly. All right, so another thing to mention here, if there is this process called exception to rule, where if you're not getting what you need through the rules that DDA has passed, you can request an exception to rule. They're not granted very often, but if the kid's situation differs from the majority of other folks, you can actually get there. So exception to rule is something to sort of keep on your radar as well. In addition, I've sort of outlined the administrative hearing process. If you get to this point, you really probably should talk to an attorney to understand it a little bit better. And then, as I mentioned, I'll sort of flip through these just so we can answer a few questions, but education, just thinking about that transition planning through the school district, that goes through to age 21. So make sure that you're doing the appropriate transition planning, which really should have started at least by age 16. But hopefully the school district's doing the job. They don't always do the job to get that transition planning going. They often have programs that are specifically for transition. In addition, in higher education, look at those programs that are out there. Get in touch with disability service offices if the child is someone that's going to be going to a four-year university or a community college. Thinking about 504 plans, which will allow them accommodations, like allowing more time for a test, and then ADA, again, allowing accommodations. Employment, there are supported employment agencies that can help keep the person employed and find employment for them. That's something that's available through DDA, and be aware of reasonable accommodations that need to be made. I'd also mention that there is another program where if the person's working too much to receive Medicaid, they will often move to something called the Healthcare for Workers with Disabilities, or HWD program. So just be aware that work shouldn't be should not prevent a person from getting access to medical care if it's not provided through work. Housing, I'll just sort of skip over that. Estate planning, the only thing I'll mention on estate planning is this is the time to look at it. You need to be thinking about tax implications, special needs trusts, and who's going to do various things once you've passed away. Specifically, who's going to be taking care of your child on a day-to-day basis, who's going to be taking care of your child's money, and who's going to get you from the point where your assets are in your name or in the name of your estate to getting them to that individual. So again, we can do a whole presentation on estate planning when we have done that for BECU, but just be aware that this is something you should think about and start talking to an attorney about. And finally, I'll again sort of move over this, but there are procedures in place and ways you can deal with the individual's own money. Probably not an issue for the majority of folks, but just be aware that there are some steps that you might need to take in order to help manage that person's money. Again, this is for their own money, not for your money that you might be providing for your son or daughter. And then, as any good attorney will, I'll give you my disclaimer and notice.